Mr. Blanche, imagine if President Biden sent his politically appointed director of national intelligence to Mar-a-Lago. You and his other personal attorneys would have been understandably very unhappy about it. Are you unhappy that the DNI, Tulsi Gabbard, was there?
Well, first of all, Biden's director of ODNI was involved in that case, as we all know. So whether okay, but that's hardly
the point. And it also involved classified documents, not necessarily voter rolls.
And again, there's a lot of classified information around voter integrity, which is something that came out during the case against President Trump and which has been publicly talked about for many, many years. So no, I'm not unhappy or happy. Tulsi can go where she needs.
This may look like a routine media interview, but it's actually a stress test for institutional neutrality. What's really being tested here is whether law enforcement and intelligence agencies can maintain public trust while operating alongside political leadership. This raises broader questions about boundaries: who oversees investigations, who appears at sensitive operations, and how much political proximity is too much. In this video, we'll break down how official explanations collide with public perception and why that collision matters for democratic accountability.
Is the Department of Justice considering bringing any additional charges here?
Well, look, I can't talk about any investigations, but I will say the following, which is that in July, the Department of Justice said that we had reviewed the files, the quote, Epstein files, and there was nothing in there that allowed us to prosecute anybody. We then released over 3.5 million pieces of paper, which the entire world can look at now and see if we got it wrong. And so it's not performative, and I respectfully disagree with that statement. We were ordered to do so by Congress and then by the President of the United States, and that's what we did. And let me, I said it on Friday, this Justice Department, the FBI, DHS, we have gone after more sex traffickers, more child pornographers, more men who have done harm to children and young women than any administration in history. And so we need to separate those two ideas, the fact that there's the Epstein files and whether there's anybody there that we can go after, and the work that we are doing every day, which is extraordinary, and we will continue to do that.
You just said that now these documents are out for the world to see and maybe something could come up. Are you suggesting that if a sort of civilian sees something that you should prosecute, that could open an investigation?
Well, look, the way that we start many of our federal cases is because we hear tips from civilians or from others in the community. But my point in saying that was slightly different. It was that the review that we had done before concluded that there was no such information, and that's where we remain for what we've seen and what we've released from the Epstein files. Now, there's a lot of correspondence, there's a lot of emails, there's a lot of photographs, there's a lot of horrible photographs that appear to be taken by Mr. Epstein or people around him, but that doesn't allow us necessarily to prosecute somebody, and that's what's important for the American people, and the victims want to be made whole, and so we want that. The Attorney General wants that more than anything, but that doesn't mean we can just create evidence or that we can just kind of come up with a case that isn't there.
Among these new files is a list compiled by the FBI just in August of numerous salacious and, to be really clear, unverified allegations about President Trump. Why did the FBI create this list last year, and have all of these claims been investigated by the DOJ?
So look, it's not about President Trump. It's about a ton of people, multiple people that were, quote, in the Epstein files. And what I think folks will see when they review the materials we released is that there have been hundreds of calls made to the FBI where allegations are made by either anonymous individuals or people who are very quickly determined to not be credible, whether it's the nature of what they're saying or the fact they won't provide any information or corroboration. And that's part of the Epstein files. So go ahead.
I understand that. But the fact that you created a list, the FBI created a list about the allegations against President Trump, is certainly noteworthy. I mean, he's a sitting president. And the question is whether or not the DOJ, but the question is, and I'm not saying that they're verified at all, and that's what my question is to you. Did you look into what you have on those lists?
Yes, of course, but no, but you're not being fair in that question, because that index, that list you're talking about was not just President Trump. It was all kinds of individuals, other politicians, other, quote, famous people, where we wanted to understand, okay, there were members of Congress that were accusing us of hiding things, which we're not doing and which we haven't done. And so we wanted to understand why and where that was coming from. And it turns out there was a number of claims made by either, like I said, anonymous people or somebody, for example, calling and saying, I used to have a roommate who told me this sensational story. So just, obviously that's not something that can be really investigated, right? What's your roommate's name? I don't remember. right?
Got
So
it.
that's what that's about. I don't appreciate it being directed towards Donald J. Trump because that pushes a narrative that is completely false. There are all kinds of people that are mentioned in the quote Epstein files that we had to look at and run down.
Yeah, no, I understand. He is the only sitting president who we're talking about. I do want to move on. Former CNN anchor Don Lemon and another journalist, Georgia Fort, were arrested on Friday on charges they violated federal law during a tense protest at a Minnesota church. A conservative federal judge, somebody who clerked for Antonin Scalia, already had rejected those warrants and wrote that there is no evidence that those two engaged in any criminal behavior or conspired to do so. Then an appeals court held up that decision. Why did you then bring this case to a grand jury after it already had been rejected by multiple judges?
So first of all, that appeals court, you're not right. The appeals court, a judge on the appeals court said that there was clearly probable cause, and there was absolutely probable cause that a crime had been committed. Okay, so it's true that they rejected the mandamus petition, but yes, by Mr. Lemon and others, it's public. And so, yes, you're right. A judge in that court had said there wasn't probable cause. But guess what? Our system doesn't allow judges to make that decision. They can make that decision to get an arrest warrant on a complaint, but only a grand jury can bring forth an indictment. And so that's what we did. We went to a grand jury, which, as you know, are 25 citizens from Minneapolis and around that decide whether there's probable cause. And that's who returned an indictment.
Mr. Blanche, I want to go, actually, I went through the entire indictment, all 29 alleged overt acts of conspiracy. And there's a lot to ask you about, but I'm just going to pick a few here, okay? Starting with overt act number 20, which says, quote, defendant Lemon told his live stream audience about congregants leaving the church and about a young man who Lemon could see was frightened, scared, and crying. And Lemon observed that the congregants' reactions were understandable because the experience was traumatic and uncomfortable, which he said was the purpose. Overt Act 21 says, quote, as the operation continued, defendant Lemon acknowledged the nature of it by expressing surprise that the police hadn't yet arrived at the church and admitted knowing that the whole point of the operation was to disrupt. Why wouldn't a jury at trial see this as a journalist observing what is happening, which is protected by the First Amendment?
Well, you conveniently left out multiple allegations in that indictment about what else Mr. Lemon did, including surreptitiously avoiding saying where they were going, being part of the planning, being part of the decisions to make sure the police didn't know this was happening and federal law enforcement didn't know this is happening. There are multiple allegations there. And guess what? He gets to have a lawyer and he gets to have a defense. And so if he wants to go forward with the defense that, oh, shucks, I was just a journalist, he can do that. But obviously, as the indictment lays out, and which you didn't read on the air, there's a lot of things that Mr. Lemon did that you would never do as a journalist. You would never do that.
Okay.
Let's be honest.
This is not about me. This is about what happened, and this is about kind of the rules of the road. I mean, there are many.
But
let me finish my question. Let me finish my question, and then you have the floor. There are countless examples of when reporters are embedded with people, with DOD, where we are told not to tell anybody where we're going. There are numerous examples of when we get embargoed information that we can't report from your agency, for example, and that has happened with presidents in both parties, and we withhold reporting it until you say it's time to report it. That's not unusual, and it's not unlike what happened with Don Lemon and Georgia Fort.
Well, listen, you are totally correct that happens every day and it's happened for decades. But if you watch what Mr. Lemon did, okay, and I do not want to have a trial right here. It's not fair to him. But I will say that if you watch the publicly available live streaming that he engaged in, the comments that he made, I mean, that's what it matters, right? It matters, like, how do we balance the FACE Act? How do we balance freedom of religion, the right of people to worship on a Sunday morning, okay, and the freedom of the press? And it's a balance that we have to engage in. I agree with you. But my point to you is that I promise you that neither you nor your colleagues can honestly, with a straight face, if you watch everything that he did in the day before with the planning and the day of with what happened, when the comments he made while the kids were crying and screaming and racing away, while the parents were looking for their children upstairs,
but he doesn't
while they were just trying to have a church service.
Okay. Bottom line question for you is,
so,
was this really about what you just described, or was it about trying to make an example out of somebody who the president has sparred with?
I don't even know that the president's even ever thought of Don Lemon. I don't know whether that's true or not. But I will tell you, we're not making examples of people. The day after that happened, the Attorney General flew to Minneapolis. She was there for 3 days. What we saw, there is no scenario under which the American people are comfortable or think that was right. I'm sorry. So no, it's not about making an example. It's about justice.
I want to move on. But earlier this week, the FBI went into the elections office in Fulton County, Georgia, to seize 2020 ballots, voter rolls, scanner images. And the president told reporters, quote, they got into the votes. You're going to see some interesting things happening. What interesting things is he talking about, and why was he so involved in an FBI and DOJ raid?
Well, just because he said that doesn't mean that he's involved. I don't believe he was involved. This is a criminal grand jury investigation, and I can't comment on it beyond what you just said, which is that there was a search warrant that was authorized by a federal judge, by a magistrate judge in Atlanta, that allowed us to go and seize those records, and they have been seized by the FBI as part of an ongoing criminal investigation.
He said interesting things are happening, so it sounds like he was briefed on it.
I mean, I don't know. I'm not around when the president's briefed or not briefed. What I said is that this is a criminal investigation, so it's a tightly held, as it must be under the law. It's a grand jury investigation, and that's how we're proceeding.
What are they investigating?
As you know, we can't talk about specifics of any grand jury investigation. I will tell you, as I said on Friday, as the president has said, election integrity is of the highest importance to the American people, hopefully to everybody in this country, Democrats and Republicans alike. And so we are doing everything we can to make sure that we have free and fair elections.
Okay, and as you well know, that when it comes to Georgia, claims of voter fraud there, because they got the 2020 ballots, have been debunked over and over again. There were multiple recounts. Why was the Director of National Intelligence, Tulsi Gabbard, present at an FBI raid?
First of all, it wasn't an FBI raid. It was a search warrant being executed by FBI agents in the middle of the day.
Why was she there?
And secondly, I don't know why the director was there. She is not part of the grand jury investigation, but she is for sure a key part of our efforts at election integrity and making sure that we have free and fair elections. She's an expert in that space, and it's a big part of what she and her team look at every day. But beyond that, I don't, like I said before, this is a grand jury investigation being conducted by a U.S. attorney, and that's where we have to leave it for now.
Mr. Blanche, imagine if President Biden sent his politically appointed Director of National Intelligence to Mar-a-Lago. You and his other personal attorneys would have been understandably very unhappy about it. Are you unhappy that the DNI, Tulsi Gabbard, was there?
Well, first of all, Biden's director of ODNI was involved in that case, as we all know. So whether okay, but that's hardly
and
the point.
And it also involved
the point
classified documents, not necessarily voter rolls.
And again, there's a lot of classified information around voter integrity, which is something that came out during the case against President Trump and which has been publicly talked about for many, many years. So no, I'm not unhappy or happy. Tulsi can go where she needs to go. She's phenomenal. She's doing a great job, and she's a partner with us. But like I said, folks want to make something out of this that does not exist. This is a grand jury investigation being run by the FBI.
What we have just witnessed is not a routine exchange between lawmakers and an administration official. It is a rare moment when the machinery of American justice is forced to speak out loud about its own limits, its own choices, and its own contradictions. When the Deputy Attorney General stated plainly and without embellishment that the Department of Justice reviewed the so-called Epstein files and found nothing that could support further prosecution, the words landed with weight. Not because they satisfied the public, but because they placed the burden of judgment squarely back on the system itself. The claim was simple on its face. Millions of pages were reviewed. Millions more were released. The public, the world, was invited to look and decide whether the department got it wrong. This was presented as transparency, as compliance with Congress, as obedience to the president. But beneath that procedural framing lies a deeper question that no number of documents can erase. When a government says it has seen everything and still cannot act, what does that say about justice in America? The official emphasized separation. Separation between the release of files and the everyday work of law enforcement. Separation between disturbing material and prosecutable evidence. Separation between outrage and legal standards. And in a narrow legal sense, that argument holds. Courts do not operate on emotion. Investigators cannot invent facts. Prosecutors cannot simply will cases into existence. The law demands proof, corroboration, structure. It always has. And yet, the tension we saw in this hearing comes from the growing gap between legal sufficiency and public trust. Because this was never only about documents. It was about confidence. Confidence that the most powerful institutions in the country apply the same rigor upward as they do downward. Confidence that proximity to influence does not quietly become insulation from consequence. When the Deputy Attorney General insisted that anonymous tips, unverified claims, and secondhand stories cannot form the basis of prosecution, he was stating a principle of due process. But he was also revealing how fragile that principle feels when it collides with years of unanswered questions. That fragility was on full display when the conversation turned to lists compiled by the FBI, lists that included prominent figures. Lists created, we are told, not to target, but to respond to accusations that information was being withheld. The defense was procedural, the intent administrative, the narrative corrective. Yet the very existence of such lists underscores the climate we are now living in. A climate where trust is so eroded that even internal efforts to catalog allegations become evidence in the public mind of something darker. The Deputy Attorney General pushed back forcefully against the idea that any one individual was singled out. He framed the process as comprehensive, expansive, and necessary. Hundreds of calls, hundreds of claims, many dismissed quickly, many lacking credibility. This, he argued, is what transparency actually looks like when stripped of myth. But transparency without resolution does not feel like closure. It feels like exposure without accountability. And that is where the discomfort sets in. The hearing did not stop there. It moved from files to force, from documents to action, from the abstract to the immediate. The arrest of journalists, the role of grand juries, the boundaries between observation and participation, the delicate balance between freedom of the press and the enforcement of federal law. When the Deputy Attorney General defended the decision to seek indictments after judges raised concerns, he leaned on the structure of the system itself. Judges do not indict. Citizens do. Grand juries decide. That is the design. And again, he was correct. But correctness does not equal clarity. Because what the public saw was not a clean diagram of constitutional roles. It was a clash of values. The right to document events, the right to worship, the authority of the state to intervene, the power of prosecutors to interpret intent. These are not technical questions. They are moral ones. They go to the heart of what kind of society we are trying to preserve. That same unease followed the discussion of the Georgia search warrant, ballots, records, federal agents. Political context hovering over every word. The Deputy Attorney General insisted this was not political, that it was authorized by a judge, that it was part of a tightly held investigation, that the president's public comments did not equal involvement. And once again, the defense rested on process. Process is the shield of institutions. It is how they justify action and restraint alike. But process alone cannot restore faith, especially when past claims have already been examined, recounted, and dismissed by recounts and reviews. Especially when political figures appear adjacent to law enforcement actions, whether by coincidence or by design. Especially when the line between independence and influence feels thinner than ever. What this hearing revealed, in its totality, is not a single failure or a single success. It revealed a system under strain, a justice apparatus insisting on rules while facing a public demanding meaning, officials defending boundaries while citizens question outcomes, law operating as designed, yet leaving so many unsettled. This is the paradox of American power in this moment. Institutions that function procedurally can still feel morally insufficient. Transparency can coexist with skepticism. Legal rigor can stand alongside public doubt. And none of these tensions can be resolved by sound bites or press releases. They can only be resolved through vigilance, through sustained oversight, through citizens who refuse to disengage simply because the answers are complicated or unsatisfying. Democracy does not survive on blind trust, nor does it survive on constant suspicion. It survives on informed attention. That is why moments like this matter. Not because they provide closure, but because they expose the stakes. They remind us that justice is not automatic, it is maintained, it is questioned, it is defended, and it is the responsibility of the public to keep watching. Subscribe to Liberty Report USA. Subscribe to Liberty.